I'm going to put this back up there. No, I think we're good.
Hey, how are you? Okay. The units working fine. Perfect. That's good. I like it. It's working good. Good. All right. I'm just saying. Is it one of yours? Oh, yeah, it is. You got a pretty white up since I see that. You got a loose white. How was your colors you made? How was your I think much pretty good though, isn't it? That works really good. You called me and I was just going to run over the show. Like, you got it. I don't know that it works for life. Yeah, thanks. Nope. Hey, don't thank me. Stop down next Thursday. Or chamber next day. I'm going to yeah. Speaker last night. By one. I should have even. Not too bad.
Yeah, just be yourself. I got it. Off we go.
If you text me, and then have to disrupt everything. I'm actually live feeding it, so I need to get up front. You're so good to me, Tom.
Someone else there. Took it jealous.
So? Oh.
Took it jealous.
I haven't seen you since last night. I haven't seen you since last night.
Was she a part of the shenanigans?
No. We left the zone that Penn
last night. Yeah.
Mansion?
Yeah, mansion.
She looked like it was overly packed down. Yeah. Oh yeah, I know. That's why I said it.
They couldn't all get in there. They're coming in the hole, staying in the hole. There wasn't that many people.
I know nothing. See nothing.
Maybe what you want to do is have a note.
Yeah.
Should be something. I always bring a legal pad. Oh, I have legal pads.
Sure.
Ladies and gentlemen, good evening. Please rise to the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Today is Thursday, March 1st, 2018. Penn Forest Township Zoning Hearing Board has an application from Atlantic Wind. This evening, I'll introduce members of the board. My name is Audrey Wargo. I'm the chair. To my left is Patrick Walsh, Paul Fogel, and Sean Presby is our alternate. Our attorney is Michael Greek. He is our solicitor. And other attorneys that I recognized from last time. And I will also be calling on the zoning officer and the code enforcement officer. Anyone wishing to speak must be sworn, so our stenographer can get everything on record. If you do have any testimony to present, please hold it until after the applicant has presented their paperwork, and we will get to you in as orderly a fashion as we can. So I will start with the zoning officer, John and Greg. Please be sworn.
You swear the testimony about to give will be the truth, the whole truth, and nothing but the truth.
Yes. Excuse me. Before we begin, may I speak?
Attorney Anders?
Yes. And I represent two objectors, Chris Mangold, who you know from the last time, and Eileen DiRigorio. I just want to make two comments to start. This venue is not appropriate. I came here at 6:30. I couldn't find a place to park. I saw people pull in, pull out. Nowhere, no, it's packed. Parking lot's packed. This should be held at the fire hall. The community has the right to participate, and this is violating their due process rights by holding it here. And I think the zoning hearing board did an excellent job the last time around. I'm not blaming anyone pointing fingers, but we really ought to move this. It should not be held here. Atlantic Wind should not dictate where you hold these hearings. This is a new application, a second application. So whatever has happened before is over and done. So there's no reason why this shouldn't be held at the fire hall.
To address your comment, we did contact, the township supervisors did contact the fire company. It was not available for this evening, and in order to schedule a date, they would have had to hold their board meetings prior to them accepting a date for as early as possible, and this was available, so that's why we are here tonight.
And I understand the logistics. Does that mean that we're going to move the next set of hearings to the fire hall?
That I don't know yet.
Well, we would respectfully request that that be done,
So no.
because we just cannot, you can't accommodate the people who want to be here. And one of their defenses in this case is they're going to object to standing. They're going to say that certain objectors don't have standing. The objectors that want to be here can't even get into this building. So, you know, we're limited to the people that are here, and they're going to say they live too far away, they're not close enough, they're not significantly affected by this project. So again, it is patently unfair to keep the community out. And I understand your logistical problems, but I ask that it be moved to the fire hall. My second objection is that we don't know what parcel they're talking about, or parcels they're talking about. They're asking for a special exception on property, but they don't identify the property. They say they're going to consolidate and subdivide. So you're being asked to make a ruling on a special exception, yet we don't know exactly what supposed parcel these turbines are going to be on. So how can you decide whether a property is appropriate when they haven't identified the property? If they're saying it's one tract, which it is, that's fine, but let them say that. But if they're saying they're individual parcels, which from the cover letter on their application seems to indicate that, then tell us what parcels they're talking about. Otherwise, it's impossible for you to give a decision as to the special exception, not knowing what properties we're talking about.
Isn't this a little bit premature since we haven't even gotten to that point yet? I mean, we haven't sworn in the zoning officer, had the public notice, the proof of publication, or anything related to this application, and there's been no testimony. So isn't it premature at this point of the proceedings?
Perhaps it is. However, I wanted to put it on record so that the argument's not going to be made later on that I've waived that objection. And I think you're going to see very quickly that they're not going to identify the specific parcels that they're talking about. There's a nebulous parcel consolidation subdivision. Thank you.
Okay, thank you, Attorney Anderson. John, Greg.
So the public notices were mailed out on February 16th. The advertisement was done in the Times News on February 15th and 22nd, and the property was posted on February 20th, 2008.
Can we have those, please?
February 20th?
Yes.
And the property was posted by whom?
Property was posted by Greg Kurtz.
Okay, you physically posted the property?
Correct.
And you did that on February 20th, 2018?
Yes.
Okay. So the board, I think initially will mark as Board Exhibit 1 the application with cover letter dated February 5th, 2018, with the zoning application, list of the parcel numbers, the wind license and wind energy lease agreement, and the map as Board Exhibit 1. Board Exhibit 2 will be the public notice and proof of publication. Board Exhibit 3 would be the proof of the letters to adjoining property owners and parties in interest. B4 would be the map indicating where the property was posted, where the parcel was posted. B4 would be the review letter as required under the zoning ordinance from the zoning officer, and B5 would be the planning commission recommendations which are required for a special exception. Any objections to those documents being admitted?
I have no objection. I do have a question. And I don't know if I could ask it at this point or
What's your question?
what property was posted? What properties were posted?
What is that, Matt?
Do you not have a copy of the application?
I do.
Properties that were posted, is it indicated on this map?
Yeah, they're all marked on.
They're right here.
And are they the individual parcels?
You can review, you certainly can review this, if you wanna review it and ask the zoning hearing officer questions, but we're gonna mark it and admit it as an
May I review
exhibit, as what they had testified that they posted it. Okay,
Attorney Andrews, we're gonna ask the zoning officer to, submit his review while you take a look at that, is that all right?
That's fine.
All right, great. John, your letter that we have?
So, an
John,
application.
could you come up so that
Thank you.
we have it?
Great.
All right, so what we have here is an application for a special exception for a by Atlantic Wind. It's an application for a special exception for a wind turbine wind energy project, which would include a maximum of 28 wind turbines and associated components, including roads, electrical components, cables, meteorological towers, and associated infrastructure. It's located on 15 parcels of land, totaling 4,917 acres. Wind turbines will be in an R1 zoning district with some roadways to the R2. Also, the applicant has requested a special exception for permanent meteorological towers if they weren't found to be part of the wind turbine project. So we did receive an application, a zoning site plan, a wind license, lease agreement, and a list of adjacent property owners. The applicant reviewed the criteria in the special section of 402 for wind turbines. And, permitted by special exception, and the applicant can address the items in the ordinance to comply with that.
Any other, does anyone on the board have any questions for our zoning officer? Turn over to the applicant.
All right, applicant.
Good evening, Deborah Shulsky here on behalf of the applicant, Atlantic Wind LLC. Also with me this evening is Craig Fox on behalf of Atlantic Wind LLC, as well as Avonbridge Renewables. My partner Ed Green from the firm of Riley Viper Holland Greco. Our professional engineer from Pinoni and Associates, Michael Kissinger, and our acoustical engineer, Mark Bistache.
Okay, everyone that will be testifying will need to be sworn. Can we do that now, please?
Certainly.
Swearing on. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
And we're certainly happy to address the parcel questions that Mr. Anders had through the course of our testimony. It was also indicated in the application form specifically which parcels are subject to the scope of this application. And as the zoning officer indicated, we're here tonight for your consideration of a special exception application to permit a proposed wind energy project on property owned by the Bethlehem Authority, who is also here and represented this evening, which property comprises of approximately 5,000 acres. And I know most of you board members have, this isn't your first rodeo, you've been doing this for a number of years now, so I know you're very familiar with the standard for special exception, and Mr. Green can likewise fill you in on that standard, but just by way of a very brief overview, the name itself, special exception, is very misleading. There's nothing special about it. There's nothing an exception about it. It is essentially by right permitted land use subject to the applicant demonstrating compliance with the specific ordinance standards, which in your case is set forth in section 402A54. And once the applicant does in fact demonstrate compliance with those specific standards, the use itself is deemed to be inherently consistent and a suitable use for the property. It's deemed to be consistent with the public health, safety, and welfare, and not contrary to any safety issues. So once the applicant meets that burden, the applicant does not have the burden to put forth any evidence with respect to general ordinance standards, which you have contained in section 116C of the ordinance. However, we do intend tonight to put forth evidence both addressing the specific and the general criteria of your zoning ordinance. Obviously, we don't want to waste the board's time by going through every section of the zoning ordinance. It's a few hundred pages like most zoning codes, and we're not required to do that. We're here for the limited scope of a special exception to permit the proposed wind turbine use. As your zoning officer indicated, we think there's only one Met Tower proposed, and we'll get into that when we discuss the project, but we think that's encompassed with the use itself. To the extent that you think otherwise, then we would request that that be considered as a special exception under your catch-all phrase, which allows for uses that are not elsewhere provided in the zoning ordinance as long as they're not prohibited. So with that brief introduction, if the board doesn't have any initial questions, I would propose to jump into our testimony.
I do have a question. In your letter to our zoning officer, this application is a new proposal and new plan and is different from the prior application submitted in April of 2016. What are you going to do with the other plan that you had in here?
The other plan is currently pending. To the extent that this plan were to proceed and be approved and not be appealed, the other plan would be withdrawn.
So you have two applications in here.
We have
the same type of project.
We have one application currently within the jurisdiction of the zoning hearing board. The other application is pending in the Carbon County Court. This application is much different in terms of the scope of what's being proposed. And the intention is to proceed with this plan.
We would like to know how you can have this application and another one outstanding. I personally do not understand how you can have two applications for the same project.
I mean, I do it all the time. I have a number of clients that proceed with different development plans. There's nothing, there's nothing.
So I'm sorry, let's have a little decorum. Let her explain.
There's nothing improper with having two applications for the same property. I mean, I've had clients that will file two different plans, not knowing yet who their tenant's gonna be, and they wanna get both approved, and then before they record the plan, they build whichever one they ultimately decide to pursue. But before this board right now is only one application.
What I think we'll do is we're gonna allow all the testimony to come in. However, I believe the board would like, since we do have objectives as well, that we would like to have at the conclusion of whatever testimony that we have findings of fact, conclusions of law, and especially addressing the issue of the jurisdiction regarding having both of these plans, both projects, one subject to the deemed approval that is currently with the Court of Common Pleas. So is it considered as a deemed approval, as well as having this one at the same time?
Okay, yeah, certainly. We're happy at the conclusion of the testimony. I was going to suggest that, obviously I know the board is volunteer, so I wasn't going to waste all your time going through a big legal pitch, but we'd be happy to submit.
I'm sorry. Sorry about that. Go ahead, I'm sorry.
I was just going to say, we'd be happy to brief any issues that you think are relevant and submit proposed findings of fact, conclusions of law, and address some of those legal issues.
Gentlemen, okay? All right, continue, please.
Before we get started, just have some pre-marked goodies for everyone.
Thank you.
Applicant one, Andrea.
A1 through A6.
Thank
Pretty much everything that we already have.
Are you ready for me to proceed? My first witness is Mr. Pock. He's already been sworn in, and you already stated your name, but could you, again, for the record, state your name and your business address, please?
Yes, my name is Craig Pock. I'm Director of Business Development for Avangrid Renewables. The address is 100 Matson Ford Road, Radnor, Pennsylvania, 19087.
And what is your role with respect to this application?
I'm responsible for the development of this project, all aspects up through permitting and construction.
And what are some more of your responsibilities with respect to this role?
So everything having to do with the real estate, all of the interface at the local, state, and federal permitting level. I've been responsible with working with the Bethlehem Authority to conceive the plan. And as I mentioned, the developer of this project, but also been doing this for right around 10 years throughout the mid-Atlantic and southeastern U.S. And most recently, I was responsible for the Amazon Wind Farm, North Carolina, in northeastern North Carolina, that was about 104 wind turbines that was built 2 years ago and commissioned last year.
And who is the owner of the subject property?
The Bethlehem Authority.
And is Atlantic Wind LLC the applicant?
Yes, we are.
And can you explain for the board how Atlantic Wind LLC is associated with Avangrid Renewables?
Yes, Atlantic Wind LLC is a special purpose entity for the development of wind energy projects in the eastern half of the U.S. It's a wholly owned affiliate of Avangrid Renewables.
And are you the authorized representative of Avangrid Renewables and Atlantic Wind LLC and authorized to appear here this evening to provide testimony on its behalf?
Yes, I am.
And does Atlantic Wind LLC have an agreement of sale from the landowner, Bethlehem Authority? And obviously they're here tonight and they can speak for themselves as well.
Not an agreement of sale. It's a license agreement that permits us to develop wind energy on the project.
I'm showing you what's been marked as Exhibit A2. Is that
I have my exhibit back here.
okay? Is that the relevant pages
Yes,
indicating
it's marked A2, wind license and wind energy lease agreement.
And do you also have a letter of authorization from the DCNR?
Yes, a small portion of road just north of Hatchery Road cuts through a corner of the Weiser State Forest. We met with the DCNR in April of 2016 and discussed that shared use of that existing road. I should note that it's not uncommon for the DCNR to grant such easements in order to avoid additional disturbance if shared road can be used. And in this letter, Tim Ladner, the Forest District Manager, indicates a willingness to cooperate with us on that insofar as providing road access and then underground for any cable crossing.
And just for purposes of the record, what you were referring to was Exhibit A3, is that correct?
Yeah, yes it is.
And is your company a participant and signatory to the siting guidelines and environmental protocol contained in the Pennsylvania Game Commission Wind Energy Voluntary Cooperation Agreement and Amendment? Boy, that's a mouthful.
Yes, and not only are we a participant, we were a charter signer of this agreement. As there are no compulsory permitting requirements at the state level for wind energy in particular, the Pennsylvania Game Commission's Voluntary Cooperation Agreement sets out a framework for consideration of sites from all aspects of flora and fauna, threatened endangered species, etc., and lays out a protocol for us to follow as we site a project.
And that agreement, that cooperation agreement is marked as Exhibit A4, is
Yes.
that correct?
A4.
So why did your company agree to enter into this voluntary agreement?
Avangrid Renewables is a leader in environmental stewardship in terms of the renewable energy projects that we develop, own, and operate. And we've been a leader in the wind wildlife effort. In fact, the U.S. Fish and Wildlife Service's plan is named after Andy Linehan, who was the former director of permitting for Avangrid Renewables, who passed away a few years ago. But he was a leader in this industry, and therefore his name's on the guideline.
And while you're talking about Avangrid Renewables, can you give the board some brief background and overview about your company in terms of what it does? I think we know generally what it does, but its locations, current facilities, including those in Pennsylvania.
Yes, Avangrid Renewables is one of the largest owners of wind energy in the U.S. We operate more than 60 projects in more than 20 states across the country. Here in the U.S., here in Pennsylvania, we operate 4 projects. The Locust Ridge 1 and 2 facility is about 30 miles west of here, and then we have 2 more projects, Castleman and South Chestnut in southwestern Pennsylvania.
And do you know how many wind turbines there are across the state?
There's approximately 700, more than 700 wind turbines currently operating in Pennsylvania.
And what factors generally go into selecting a viable candidate for a proposed wind turbine project?
So you fundamentally need 3 things to do a wind project, and without any one of these, a wind project doesn't work. You need wind, you need access to transmission, and you need land that can be developed.
And before we get to the actual specifics of this particular project, can you give the board a little bit of background on wind energy in general?
Yeah, so the process of wind energy is the process of converting energy from the wind into electricity, and that happens whenever the wind flows across a wind turbine. Modern wind turbines then turn to the wind, sense the speed of the wind, and adjust the pitch of the blades accordingly. That converts the kinetic energy of the wind into rotational energy of the blades, which in turn turns a generator, producing electrons that then flow out of the wind turbine through a local collector system and then into the grid. And then the laws of physics dictate where those electrons will flow.
And are you familiar with this particular property that's currently pending before the board for this application?
Yes, I am.
And how long have you been researching this property and proceeding forward with your due diligence with respect to considering this as a possible candidate?
Yeah, we first became aware of Bethlehem Authority's interest in developing this project for wind energy when they contacted us in about 2009. And then we came to an agreement in 2013 with the authority, and that's referenced here in our agreement.
And do you know whether the owner wanted to develop the property for wind energy for other wind users before entering into the agreement with you?
There was another developer involved early on that, to my knowledge, didn't advance any plans whatsoever. I don't know that they've ever developed a project anywhere. I don't think that
Objection to the relevance
exists.
Of what some other wind company did or didn't do.
So noted.
And I guess before we, because I don't think that formal party status was granted to anyone, so I don't know, I didn't want to spend a whole lot of time on that particular issue. I was going to maintain an objection. We would be in agreement that anybody who received individual notice under the requirements of your zoning ordinance would in fact have standing because they would be in close enough proximity in accordance with the MPC and applicable case law to allow them to have an interest, which needs to be adverse. Anyone who did not receive notice under the zoning ordinance, we would take the position that they do not have the appropriate standing, and we would object to them being made a party.
Well, I don't think we've made anybody necessarily a party. I mean, Attorney Andrews has indicated that he has neighboring property owners.
That's correct.
So I don't think he's precluded from raising an objection. And since there hasn't been anybody else that has said anything, once again, this is premature. We're not gonna, this is a public hearing, and that may be an issue of standing before the board and whether enough that their testimony may be relevant based upon that standing, or it may be a matter of their ability to appeal to a higher court. And that's not something we're gonna decide right now off of the mere fact that this attorney made an objection.
Okay.
We're not going to go through everybody in the crowd here to raise the issue of standing at this point in time. I would like to get the testimony on the record for the hearing.
Was not anticipating doing that, but my understanding of the law was that I have no problem with anybody asking questions or often obviously public comment at the appropriate time, but to be a party, you have to have standing, and in order to cross-examine witnesses and raise objections, you have to be a party.
So noted. Continue, please.
I'm not sure if I asked you this yet, so I apologize if I did, but is there a particular reason why land generally owned by municipal authorities is generally more suitable for wind projects?
Oftentimes, municipal authorities, water authorities in particular, own land that's high up in the watershed or near ridges. They're able to capture the water up high, and there isn't much running into it. And then there's extra land that they can protect their resource. And in the case of the Bethlehem Authority, there's, I think, over 12,000 acres or thereabouts in total surrounding their reservoirs. Bethlehem Authority has an agreement with us, and we have agreements with other water authorities on other projects, such as Locust
that's sustained.
Ridge.
I don't think that's relevant. Let's deal with this project. Why this site is suitable for what you're doing. Whether authorities in other jurisdictions or other areas are suitable sites, I don't think is relevant to a particular site.
Okay, I might finish answering your question though, insofar as the Bethlehem Authority's residual land is passively used as open space by many in the public. The Bethlehem Authority has an active forest management plan, is managing carbon credits on the property, and it is a compatible use with our use insofar as our use is quite limited in its footprint and in its impact on the land.
I was going to ask the witness if there's he's a nearby facility, wind farm facility that's close by. I was going to ask a few questions about that if the board was interested in that. If not, I can move along and try and stay more precise to this particular property.
Do you want to hear that?
If it has actual bearing on this application, I'll
Okay.
listen to a couple questions.
It's just a few. We can go through it quickly. I think you mentioned earlier on that your closest Locust Ridge project, how far away is that from the subject site?
Approximately 30 miles,
And how many turbines are located within the Locust Ridge project?
64.
Do you know how many residential homes are within a 1 mile proximity to that project?
Just over 2,300.
And do you know how many residential homes are within a 1 mile proximity to this particular project?
Yeah, so within 1 mile of any one of the turbines here, there's approximately 130.
As part of your investigation of the viability of the site for this particular property, did you also construct 4 temporary meteorological towers on the property?
Yes.
And what process was involved to obtain approval for those Met towers?
Beginning in 2013, we obtained conditional use permits for two temporary meteorological towers that involved consultation with the Penn Forest Planning Commission and then a hearing before the Penn Forest Township Board of Supervisors. We erected those 2 in 2013, I believe, and then again in 2014, the same process with the Planning Commission, the Penn Forest Township Board of Supervisors, to obtain permits for the second 2 temporary meteorological towers. In both those instances, there was public notice, press coverage, etc.
And you mentioned the general siting factors for selecting the location of viable candidate for wind turbine project. Based on your investigation, do you know why Bethlehem Authority chose your company for this particular project?
Objection to what why Bethlehem Authority, they can testify for themselves.
And why did you find this particular property suitable for the project?
As I mentioned before, it has wind resource available to it. It has a transmission line crossing through the center of it, and it's properly zoned and has a lot of area that is lacking in human constraints in terms of homes in the property. There's certainly a number of homes around the property, and then there's available land to build that appears to be free of environmental constraints, away from wetlands, away from the reservoir, which is a very big concern for the Bethlehem Authority, is preserving that water resource. And we can develop this property effectively without impacting those resources adversely.
And did you consider any other properties in Pennsylvania?
Certainly.
Objection to
that's
relevance.
exactly my job, is to evaluate.
Whoa. What do you have to say with that? What's the relevant of considering
I was
other
going to bring him back to
locations?
why he chose this particular site, why this was an appropriate site based on investigation of other properties that he considered.
Okay, I don't think that's relevant to the outcome here.
Okay, we'll proceed. And this was kind of one of the questions that I think Audrey was initially asking me. Before we get into the specifics of the particular application and the plan that is before the board now for their consideration, can you explain why you decided to submit a new application and new plan?
Yeah, this site is a very good wind energy site. It has all those components of land, wind, and transmission available to it. We believe that the plan that's before us, and even the plan that we submitted 2 years ago, meets all of the requirements of the ordinance. And we hope to put a plan together that does satisfy this board, gains approval, and that can move forward and produce clean energy in the community. And so we've advanced that, listening to input from the community. We've adjusted this application, taking into consideration advances in technology and the community's input, and we would like to proceed with this plan tonight.
Mr. Poff, who gets this energy? If this plan were to go through, where does this energy go?
It flows into the grid locally and would go into, if it were built today and the wind were blowing, these lights would, the laws of physics indicate the energy would be coming into these lights.
So that differs from the previous application.
No, ma'am, it does not. You asked me where the energy flows. The laws of physics dictate where the energy flows.
The last time
and that particular issue has no bearing on the zoning of the property.
I think she was asking a question, and just a general question of where the power goes to, because last time you brought it up that it would be put out to the grid, it can go to New York, New Jersey, Delaware, I believe is what, if my memory is correct, what was said at the firehouse, stuff like that.
No, I think that was a bit of confusion. The grid here is interconnected to all those places, but the laws of physics dictate where the energy flows.
I understand the grid very well.
It flows to demand.
Yeah, really.
Okay. And
Okay, thank you. Go ahead, continue.
Okay. I'm gonna wait till everyone quiets down before I speak. Can you generally explain for this board the existing conditions of the property, and then you can walk them through what's being proposed as part of the project, and for purposes of the record, you'll be referring to what's marked as Exhibit A5, Sheet 2 in your packages.
Okay, so before you, there is a location map in the upper right-hand corner that shows generally the Bethlehem Authority's property is in the eastern or southeastern quadrant. On the plan here, this linear feature going up the left side or to the west of the property is the Pennsylvania Turnpike. Just to the west of that would be Route 903. The yellow is representative of the lease that we hold with Bethlehem Authority in Penn Forest Township. I should note it extends into Monroe County. For purposes of tonight, we're just showing the Penn Forest side of it. The bright green line outlines the subject of tonight's application.
And if I could just stop you there, because I know there was a few questions about the parcel. Are the parcels delineated on the plan itself? Which parcels comprise the project area?
Yes, towards the bottom right quadrant, there is parcel data, Penn Forest, and adjoiners, a table that shows all of the owners, parcel numbers, and their use. So getting back to the plan itself, I mentioned the Pennsylvania Turnpike to the west. There is Reservoir or Hatchery Road through the center of the property. To the north would be Talminson Trails and other communities and Stony Mountain Road. To the south would be Beltsville Lake Estates and Forest Lane. And then to the east would be Monroe County and the reservoirs themselves. On the plan, we have indicated 28 wind turbines. Those are the round features that you see. Connecting all those would be a blue line that is representative of the road and the underground and overhead electrical and fiber cables that connect back to a substation that is adjacent to the existing transmission lines. And then also on this plan to be testified to later would be some drainage symbols.
And can you point out where the Met Tower is?
Yeah, there is a permanent Met Tower proposed in the very west of the property on the south of Reservoir Road, between the westernmost turbines and the Pennsylvania Turnpike. And that permanent meteorological tower is necessary for the safe and efficient operation of the project. It would be approximately 370 feet tall.
Is that the only one, Mr. Pop?
Yes, sir.
how many towers were in the original?
Meteorological towers?
No, turbines.
The original application had 40 proposed turbines.
Okay.
And I believe 2 meteorological towers with an alternate.
Okay.
But the application that was before us included how many towers?
40.
It had 3 permanent meteorological towers, 2 proposed, 1 alternate, and 40 wind turbines.
But did the Lehighton Water Authority not approve some that were on their property?
Lehighton had 3 turbines on its land. I was speaking to the original application. That
Right.
was the question.
Okay.
That's well, thank you.
I think you covered the infrastructure. I'm not sure if you started to talk about where the operation and maintenance building would be.
Oh, yes, we have elected to further reduce the footprint here by moving the operation and maintenance building off-site to a commercial property off-site. There is a construction laydown area shown right along Hatchery Road. I mentioned the substation. We previously mentioned that short stretch that crosses the very corner of Weiser State Forest. All of this represents approximately $125 million investment. If built, the project would pay property taxes to the tune of $120,000 a year, $100,000 of which would go to the Jim Thorpe School District.
All right, please, she has to we're taking a record here. We understand you may disagree with his testimony, but we're trying to keep a record, please.
So approximately $100,000 would go to the Jim Thorpe School District based on today's tax rates, and approximately $20,000 to Carbon County. As you likely know, Penn Forest Township does not have a property tax, but an earned income tax, and the 4 to 10 permanent O&M workers on the site would certainly be subject to that.
Now, is the site monitored from a central location?
Yes, so during the typical work days, there will be an operation and maintenance crew that's responsible for the safe operation and maintenance of the project. When they're not on site, this plant, as well as all of our plants, are connected to a national control center. So it's monitored 24/7, 365. If there were ever any sort of emergent situation, the NCC, a secure facility in Portland, Oregon, has visibility and control of the project. If we need to dispatch anyone from emergency services or an O&M crew, the NCC has that capability 24/7, 365.
So your company has a certain protocol on safety?
Absolutely. Each site has a specific safety plan that considers the conditions on the site, the conditions and existence of local EMS, the local infrastructure, all aspects, the environment. The weather conditions are different here than, say, they would be in the desert Southwest. All of those go into an operation as a safety plan for each project.
And are all these associated improvements that you just testified to, in your opinion, necessary in order for the wind turbine facility to function and operate, including the Met Tower?
Yeah, so a wind turbine requires wires to move it to the grid, a substation to connect it to the grid, a permanent meteorological tower to assess the performance of the project, and all the communications equipment that communicate with the grid operator and back to the NCC for safe operation.
And is the local approval the first step in the process?
Yes, it is.
And assuming that the board were to grant this application, what other agency consultations and third-party permitting would be required?
I'm going to refer now to A5 and page 3. It's entitled Additional Known Permits, Consults, and Coordination. This is a list of where we go next after Penn Forest zoning. We would necessarily come back to the Township Board of Supervisors for subdivision and land development approval, and ultimately for building permits. We are presently working with PJM Interconnect on the studies to ensure that the interconnection of a project such as this to the grid ensures the reliability and stability of the grid. We have consulted with the Federal Communications Commission and determined that there are a number of microwave beam paths that traverse this site. That's FCC regulated airspace. So we have sited our wind turbines to avoid those regulated airspace areas. We have, next would be the Federal Aviation Administration. We have submitted applications for a determination of no hazard for a variety of turbine locations here. Those are presently before the FAA. They regulate everything above 200 feet in height, not only for civil aviation, but also military aviation. And then FAA coordinates with the Defense Department Siting Clearinghouse for additional military airspace, such as radar, air surveillance radar systems, the SRS radar, as well as NOAA, the Meteorological Service. All that feeds up through FAA. We will also consult with the U.S. Fish and Wildlife Service with regard primarily to the Migratory Bird Treaty Act and other federally threatened or endangered species. We will be with the U.S. Army Corps of Engineers for wetlands permitting and any impacts to waters of the U.S. I mentioned earlier our voluntary siting, or voluntary cooperation with the Pennsylvania Game Commission's process. They will be a necessary step here to assess the wildlife, including birds and bats. The Pennsylvania Fish and Boat Commission are part of that process as well, assessing water and invertebrates and amphibians. The Pennsylvania Department of Conservation and Natural Resources, I mentioned we've spoken with them about the Weiser State Forest. They'll be part of that PGC voluntary agreement as well. We have a stop with the Pennsylvania Historic Museum and Commission for cultural, archaeological, and historical resources. We will be dealing with the Pennsylvania Department of Environmental Protection for air, water, and stormwater. The Pennsylvania Department of Transportation, the Reservoir Road, 903, the Turnpike, all of those local roads that service this proposed project are state roads. So we will be obtaining permits from PA DOT. And then also the Carbon County Conservation District is responsible for stormwater, quantity and quality management. And these are agencies we know of today. Often it's not uncommon through the process that something arises, a concern with some of these agencies that necessitates consultation with other agencies, native tribes, or any number of other potential NGOs or agencies.
You testify that one of the factors considered in selecting a location for a wind energy project is the relevant zoning ordinance for the property and the requirements under the applicable zoning. Is that correct?
Yes.
And are you familiar with the relevant zoning ordinance requirements under the Penn Forest Township zoning ordinance?
Yes, I am.
And was the project designed to be in compliance with those applicable standards?
Yes, it is.
And did you also retain a civil professional engineer to prepare a plan in accordance with the ordinance standards?
Yes, and Mike Kissinger will testify later tonight.
And do you understand that there are specific ordinance standards governing the wind turbine use itself?
Yes.
And was the project designed in consideration of those specific standards?
Yes, it was designed to comply with each and every one of those.
And let's go through those standards. We can do this very quickly. Do you know what the setback requirement is pursuant to section 402A.54, small letter case A?
Yes, it's an occupied dwelling setback that is, it's a function of the height of a proposed wind turbine. In tonight's application, we are specifying the dimensions and qualities, and we'll refer to the specifications of a Vestas V136 turbine with 112 meter hub height. So that package has a tip height, meaning when the blades are in its 12 o'clock position, it has a tip height of approximately 592 feet. For purposes of our site design, we assumed 600 feet. We rounded up 8 feet. And so by virtue of the mathematical calculation of 452A4A, 3 times that tip height would be your required setback. So 3 times 600 would be 1,800 feet. That setback line is delineated on the plan. Anywhere a home is within 1,800 feet of the property, we have gone to those homes and drawn a red dashed line onto the plan. So that shows where we would be precluded from building a 600-foot turbine would be in this area just to the north of Beltsville Lake Estates in the far southwest, southeast part of the property. There is an area that's precluded from development by that setback right along Hatchery Road in the western part of the property. And then a very small little section in the far northwest, I believe Hickory Run, I believe, excuse me if I have that wrong, but in the very northwest of the property.
So let's focus for the moment on the closest home on the plan to the closest proposed turbine. Can you show on the site plan where that closest turbine is and what the proposed distance is to that closest home?
Yeah, so in the far southeast part of the property, this turbine that comes down at the end of the string is 2,295 feet from the closest home in Beltsville Lake Estate.
So based on the proposed distance of 2,295 feet, I believe you said, if my math is correct, you would be exceeding the minimum required setback under the ordinance by approximately 500 feet?
Yes, the required is 1,800 feet. We're proposing almost 2,300 feet. That's 495 feet greater than required.
Now, under the ordinance, could you build a taller turbine based on the proposed 2,295-foot distance?
Sure. If you
Objection
divided,
to the relevance.
if you divided
What they could or couldn't do. What are they doing here?
Yeah, I think we have to sustain it. Why is it relevant as to what he could have put there as opposed to what he's doing?
Well, I would take it to mean that it's relevant because he's exceeding the ordinance requirement, and if the burden shifts, if the burden shifts as to the health, safety, and welfare, they have to prove that what is being proposed is more adverse than another normal wind turbine project. And we would be demonstrating that we are well in excess of what the minimum requirements are under the zoning ordinance.
I think that's what he testified to already.
It was already testified to. I think the board understands that. The board understands.
Would you be agreeable to accepting as a condition of approval, should the board grant this application, that you would commit to not exceeding 600 feet, even though the proposed distance is greater and you could build a taller turbine?
For purposes of this application?
For purposes of this application.
Yes.
I'm a little confused here now, because if you're submitting this application indicating what the height limits are and the locations of that, how would it be, are you seeking approval for the plan as it's submitted? You just asked him that whether he agrees to keep it at what's written in what you have prepared here.
Well, I guess it would depend on what conditions. It really would depend on how the board would draft the decision. I mean, I've seen it where they've just approved it, but they haven't incorporated any specific conditions or anything regarding the testimony. So I'm offering it, and I'm actually offering it to say, yes, we will agree and will accept it as a condition of approval,
Okay.
that it will not exceed 600 feet.
Okay.
So
That's
we're
fine.
trying to do it as
I just didn't understand where you were going with that. Okay.
Yeah.
It wasn't.
No, I wasn't
formulated
trying to
that
be
way. The
sneaky,
question
but I
didn't
was-
come out that way, and
I apologize.
All right.
I apologize. It was meant to be
Okay.
a commitment.
Okay.
Okay, so we talked about the closest distance. How about some of the other distances to some of the other surrounding properties?
Yeah, so again, I'm now referring to applicant's exhibit A5, page 4. On the northern side of the property, the closest home to any turbine on this string of turbines that are oriented east and west here is 5,742 feet from any home that is on LIPA. So we're over a mile away from any homes to the north. Here in the central part of the site, we're approximately 5,200 feet from any home along Hatchery Road. So again, 1,800 feet required, and we're proposing 2,300 feet on the south, over a mile on the north, and approximately a mile off of the homes in Hatchery from existing occupied road.
So I think you covered the first part of this setback requirement. Is there also another requirement set forth in section 402A 54A subsection 1 relating to distances to the lot lines?
Yes, and that requirement is that the height to the top of the turbine hub, whatever that height is, the turbine must be set back from a lot line. And in this case, we'll go to the closest of any. I mentioned earlier the height to the top of the turbine hub would be 370 feet. This farthest northwest turbine is situated 370 feet off that, it's actually 371 feet off that lot line. The adjacent owner on the other side of that green lot line is also the Bethlehem Authority. The closest home to that farthest northwest turbine, or northeast turbine, I'm sorry, is approximately 5,382 feet. And that is up in the far northeast of the property.
So would you be proposing at the time, should the plan proceed forward with the land development, to also consolidating certain parcels and creating a subdivision line as part of the land development process?
Yes, that's exactly what's contemplated here. Again, I mentioned the entirety is, the Bethlehem property is the entirety in yellow. And then what is proposed is that a subdivision or consolidation plan create two separate lots, one south of Hatchery Road and one north of Hatchery Road. And that will be bounded on the north by and east by Bethlehem Authority property as well.
And does the ordinance also contain a setback requirement pursuant to section 402.A54B that the turbines not be located within the 50-foot front yard, 40-foot rear yard, and 35-foot side yard that would apply to any principal building?
Yes, and by virtue of the fact that the previous section requires it be 370 feet from a lot line, we far exceed the minimum required.
And in compliance with section 402A54C, to the extent that the facility were to cease in the future being operated as a wind turbine facility, is the applicant agreeable to removing all above ground structures within 12 months from the time when the turbines are no longer being utilized to generate electricity?
Yes, we will comply with that requirement, and further, the agreement we have with Bethlehem Authority specifically requires the removal of the equipment if they stop generating, and it further requires that we post financial security to ensure if our company is insolvent for any reason, security exists for the Bethlehem Authority to undertake that work themselves at our expense.
And again, assuming the facility were to cease to exist, would any new driveways that were installed be removed and any disturbed earth be reseeded?
Yes, as required by the ordinance.
And does note 1 on the plan also confirm this obligation?
Yes.
And would you also accept as a condition of approval should the board grant this application?
Absolutely.
In compliance with section 402A54D, will the wind rotors comply with the minimum height requirement, which is the lowest position of the wind rotor being above 25 feet above the ground?
Yes, and in fact, with the V136-112 package that we specified earlier, the minimum distance when the rotor is in the 6 o'clock position would be 44 meters, I believe, above the ground, or approximately 144 feet. So where it's required to be at least 25, we would be well over 25.
And does note 2 on the site plan also confirm compliance with this requirement?
Yes, it does.
Are the turbines climbable externally?
No, they are secure at the base, and you can only climb a turbine internally.
And there's an elevator inside, right?
In most of them these days, yes.
Are there certain standards that are applicable to the actual construction and design standards of wind turbines?
Yes, there are.
And in accordance with section 402A54E and F, will the turbines be constructed and installed in accordance with all applicable Uniform Construction Code, building codes, National Electric Codes, and American National Standard Institute requirements?
Yes, and again, referring to A5, page 6, we have excerpted specifications from the Vestas turbine on the right, and then other electrical specs that would be required for installation of, say, the substation, the electrical cables, all of those sorts of things are enumerated here and include the Uniform Construction Code, the International Electrical Codes, the American National Standards Institute, among others.
And how many projects would you say your company has designed over the years in the U.S.?
Well, as I mentioned earlier, we have over 60 operating today.
And are all these projects designed in accordance with all applicable industry standards?
Absolutely, yes.
And does note 3 and 5 on the site plan also confirm this obligation?
Yes, it does.
And would you also be agreeable to accepting this as a condition of approval should the board grant this application?
Yes, we would.
Will the associated electrical wiring be placed underground to the maximum extent necessary?
Yes.
And does note 4 on the site plan confirm this requirement?
Yes, it does.
And in compliance with section 402A 54G, will the turbines be equipped with a redundant braking system, including aerodynamics, overspeed controls, and mechanical brakes?
Yes, referring to A5, page 7, we've excerpted the braking and overspeed specifications for the V136 turbine, and I've highlighted that it shows the redundant aerodynamic and mechanical braking means, as well as the program and system for overspeed conditions.
And does note 5 on the site plan also confirm the braking system will be designed in accordance with all standards?
You said note 5?
Note 5.
Yes.
And just so I can move things along, I'm assuming that any of the notes on the plan there, you would agree to accept as a condition of approval?
Yes, we would.
With respect to aesthetics, in compliance with section 402A 54H, will the color of the turbines be either white, off-white, or gray?
Yes, referring to A5, page 8, we've excerpted from the specifications the V136 turbine, the color scheme for the nacelle, tower, and blades being RAL 7035 or a light gray.
And I know you spoke about the Federal Aviation Administration earlier. In compliance with section 402A 54I, will the wind turbine facility meet all applicable lighting requirements dictated by the FAA?
Yes, the FAA will determine which turbines will be lighted and how they'll be lit, and we will comply with their requirements.
And is that likewise noted as note 7 on the plan?
Yes.
Is there any other lighting that's proposed other than security lighting?
No, there's no other lighting proposed.
And in compliance with signage requirements as set forth in 402A 54J, will the turbines display any advertising except for possibly a single sign up to 5 square feet?
We are not proposing any advertising on the turbines greater than 5 feet, so we'll certainly comply with that.
And in accordance with section 402A 54K, will appropriate safety signs be provided at the substations and any electrical transformers?
Yes. There will be certainly more than one required by the ordinance.
And this is also noted on the plan as note 7 and 8, is that correct?
That's actually notes 8 and 9.
8 and 9, thank you. In compliance with section 402A 54L, will there be any guide wires on the towers? On
No,
the turbines?
modern wind turbines do not require guy wires.
And is this also confirmed as note 10 on the plan?
Yes.
In accordance with section 402A 54M, have you made reasonable efforts to avoid any disruption or loss of radio, telephone, or other similar signals?
Yeah, as I indicated before, we've consulted with FCC, who sited the turbines out of those areas. We've also investigated or looked at the radio and TV signals in the area and believe that we've avoided those by our layout.
And to the extent there were any impact, how would you mitigate this?
But typically, if there's interference on, say, at someone's TV antenna, you can apply an amplifier or a booster to that.
And would you accept this? Would you?
Could we quiet down, please, so we can...
You don't realize how it...
She has a difficult time hearing this. Our reporter.
Would you be agreeable to accepting this obligation to mitigate to the extent it was necessary as a condition of approval should the board grant this application?
Yes.
In compliance with section 402A 54N regarding building setbacks, do the electrical facilities meet the building setback requirements of 50 feet for the front yard, 40 feet for the rear yard, and 30 feet for the side yard?
Yes, as you can see, the substation along the existing electrical transmission lines are well beyond those dimensions.
And you previously testified that you retained a professional engineer to prepare a site plan, which you've been referring to throughout your testimony, correct?
Yes.
Is it your understanding, and the engineer will provide more details, but the plan that you requested be prepared comply with section 402A54 with respect to showing the locations of proposed driveways, areas of woods proposed to be cleared and preserved, and the location of the turbines?
Yes, this plan complies with those requirements.
And did you also retain an acoustical engineer to perform an acoustical analysis in order to demonstrate compliance with section 402A54P of the ordinance with respect to the sound levels?
Yes.
And Mr. Bastache is here this evening. Will obviously be providing separate expert testimony in that regard. Is that correct?
Yeah, he'll be demonstrating compliance with that requirement as well.
And did you authorize Mr. Bastache to make certain commitments on behalf of the applicant during the course of his testimony?
Yes.
With respect to section 402A54Q, will the applicant be proceeding forward with subdivision land development approval at the appropriate time?
Yes.
And I think you mentioned that you would be merging and consolidating the lots as part of that process.
Yes, specifically to the bright green line indicated on the plan.
In the course of the future land development design and third-party permitting, is it possible that the location of certain turbines may change slightly in order to accommodate any environmental constraints or issues that may come up in the future that are not necessarily known at this time?
Yes, so oftentimes during the permitting process and even during the construction process, one might find certain instances in the field or in the permitting process that necessitates avoidance of certain environmental features typically. Maybe there's some wildlife or oftentimes in Pennsylvania ridges there's rattlesnake dens that need to be avoided, or certain, there's a sedge that occurs on this project we may need to avoid, and we would want to be able to adjust minimally to get around those. An example of how this is accommodated at the federal level is the FAA determinations of no hazard come with the ability to move a turbine within 100-foot radius of the applied coordinate. And that enables you to adjust in the field without need to go back and reevaluate. But if we go beyond 100 feet, we would have to go back to FAA and start that process again.
But even assuming that there are some slight variations as to the locations of the turbines based on the permitting and some of these issues you just testified to, are you agreeable to accepting as a condition of approval that you would maintain a minimum 2190-foot setback to the nearest dwelling?
2,195 feet from the nearest dwelling.
Did I get that wrong?
I just wanted to make sure it was clear. Yes, our intention is not to move anything greatly. It's just to allow a little bit of flexibility to best accommodate the site features.
And again, for purposes of the record, the required setback based on the maximum proposed turbine height is 1,800 feet. Is that correct?
That's correct.
Are you familiar with the general special exception standards set forth in section 116C of the zoning ordinance?
Yes, I am.
And you heard me say earlier that typically the applicant is not responsible to demonstrate compliance, but you feel nonetheless that this particular plan does comply with those general standards.
Yes, I do.
And the first standard is compliance with all the specific standards, and I think, correct me if I'm wrong, but you walked through the specific standards set forth in section 402A54, is that correct?
Yes. We've explained compliance with each and every one of those.
And in compliance with section 116C2, I believe you already testified as to obtaining all those various laundry lists of 14 other consulting and third-party agency permits, is that correct?
Yes, those state, local, and federal agencies, yes.
In compliance with section 116C3, will the turbines create any hazard or congestion with respect to traffic?
No. As I mentioned, there's 4 to possibly as many as 10 operation and maintenance technicians that would work 8 to 5 on this site, so we would not expect any congestion on the roads from 4 to 10 employees.
And in addition to just the normal legal standard that I'll be addressing to the board in the brief about the use itself being inherently beneficial once the specific standards are met, are there other reasons based on this plan that you feel go beyond certain standards that would make this plan more so in character with the neighborhood and not be adverse to the neighborhood?
Certainly, we far exceed the setbacks in terms of occupied dwellings. We meet all of the other standards enumerated in 40254. There would be minimal impact on the roads, as we just mentioned. No additional sewer requirements, water requirements, no school children added to infrastructure or school district needs. So all of those, we've checked into all of those and believe that our impact on those would be negligible.
And with respect to section 116C6 governing safety, will this particular use create any significant hazard with respect to fire, toxic, or explosive hazard greater than that would normally be expected from another similar wind energy facility? Sorry, did I bore you? Yeah.
No, we would not expect that. And again, the safe operation is tantamount to our effort on a daily basis. And so there will be a site-specific operation and maintenance plan that addresses everything from handling of site emergencies caused by health or wildlife incidents or any number of meteorological events, anything and everything. We regularly drill with local EMS, and we've been asked, it is a volunteer fire department coverage in this area. That's the case on all of our projects for the most part. And so we coordinate and assess what's necessary from our side to supplement EMS services and train and coordinate all of our efforts with local EMS.
And that's all the questions I have of this witness.
Anybody on the board have any questions of the witness?
What's the height of the meteorological tower?
370 feet.
Okay.
What's the reason for the subdivision?
The reason for the subdivision is an artifact of some of the input we gleaned from the last application about a zoning issue. And so it was mentioned last time that the Bethlehem Authority was open to such consolidation of lots and subdivision, and it would essentially preclude that other argument that was being made. We're not acknowledging the validity of that argument, but this is an easy way to avoid that argument.
So ownership won't change?
No, this is still owned by the Bethlehem Authority entirely.
Will you be trying to change any zoning of these lots?
No, we are not proposing any sort of zoning or property transfer with that subdivision. It's simply a legal process to preclude that other argument.
And how did you get the dollar amount that the school district's going to tax you?
So we
The
simply
school
look.
district is what? I didn't hear what you said.
That the school district is going to collect for...
Correct. Thank you.
So we own a number of projects in Pennsylvania. We pay taxes on those projects. So we used our experience there based on the taxing authorities in those jurisdictions, and then looked at the taxing framework of Jim Thorpe School District and Carbon County and applied those lessons to this project. And that's how we determined the expected property tax payment.
So they don't go by the cost of the project?
Not necessarily.
How are you going to monitor the sound of the windmills itself on the sound level? Is that going to be an independent person, or are you guys going to monitor the sound itself?
We're here demonstrating the compliance with the requirements.
Correct.
Tonight. Monitoring and enforcement of zoning is simply that. It's enforcement of regulations by whoever is going to enforce that. So We are committed to operating our project within all of the requirements, sound included.
So the sound of the unit itself will not go over the 45 dBA. Is that 2 feet in front of it, or is that 50 feet away from it, or is it a mile away from it?
We actually
What's-
haven't.
You are going to hear
Okay.
from a sound expert right after me,
Okay, I
and
just,
he can go into detail with those
Thank
sorts of
you.
answers. Much better qualified than I.
Anybody else on the board have any questions? I had one. The, when you were referring to the distances, you were referring from the lot line, and you kept pointing to the tower that you have on the upper right-hand corner. How far is that?
So this northeasternmost turbine is 371 feet from the green lot line
Okay.
immediately to the east of it.
Well, what's that area in the middle of that exhibit that's all white?
That is the Palmerton Fishing and Hunting Club property.
And, okay, and how far is that other proposed turbine that's on the little corner of it over there?
There's one at the top left and there's one at the
Yeah, how
top
far
right.
away are they? Because that would be a lot line, wouldn't it?
Let me get a scale. It's certainly in excess of the minimum 370 feet. I can give you an exact number. Or as best as I can at this scale.
Craig, if you want Mike Kissinger to testify to that.
Yeah, I know.
By my scaling of this plan, this turbine that is immediately east of the northeast corner of the Palmerton Fishing and Hunting Club appears to be in the neighborhood of 700 or 800 feet.
Any other one?
And the one to the west of the northwest corner is in the neighborhood of, I'm going to say, 550 to 600 feet, maybe.
Okay. And
Well,
you said-
well over the 370.
Okay, and you're saying the one on that top right, the one on that top right one, and it will reflect that it's the one on the very, what would be northeasterly section of the map, correct?
Yes.
Northeast, the top northeast corner. That to the easterly lot line that's 370.
371.
371. Okay, and the property it's adjacent to is because of the way the lot it's still a lot line, but it's still the water bill. All right.
Yes.
And then, based upon geological concerns, those locations may be moved, correct?
Well, not necessarily geological. It may be flora, it may be fauna, it may be some permitting requirement that we're not aware of. It may be determination from the FAA.
Okay.
So any number of these permitting processes may suggest or encourage us to avoid some sort of impact along the way. And so we're looking for the ability to adjust in order to minimize those impacts that would allow us to go ahead and get the permits that are required.
So if the project is approved, and as you had agreed to before, and I think was testified to, that the project would be laid out and built as is indicated on here, that may not be correct.
Well, it would generally be correct with a little bit of flexibility in there. It's not uncommon in my experience, having been developing a variety of different uses for the last 20 years. At zoning, we demonstrate compliance, and then we come back at land development, and then demonstrate exactly how we can employ all of the stormwater, the road design within the compliance envelope that's been demonstrated through zoning.
Craig, is it similar to like a residential development where you show the footprint, but the house could move along anywhere within the footprint as long as it's still compliant with the applicable setbacks for that footprint?
That's exactly how we foresee that.
But you've still committed that you are going to maintain that setback to the nearest dwelling of 2195 feet, correct?
2,195 feet, yes.
Oh, I'm sorry, did you indicated you had, You had
Few
neighboring
questions.
property owners, and who did you say you were representing?
Mr. Mangold and Ms. DiGregorio.
Okay.
And-
You
and
wanna
it-
spell that?
Yes.
I'm sorry, who was the other?
Eileen DiGregorio. DIGregorio.
Thank you.
And again, I'm just gonna object, I don't mind if Mr. Anders asks questions, but my position is that to cross-examine a witness, you have to maintain the appropriate party status in order to do so.
Well, I think, given the fact that these towers can move basically anywhere upon the property that you have, based on your witness's testimony, I think anybody that comes in here is gonna probably have standing as a party, so we're gonna allow them to ask the questions. You can raise your issue as standing, but I feel we're gonna allow, at least ask questions and let a higher court determine that, but you're indicating the distance is away, and you've already testified that they may not even be there, so it could be any neighboring property owner.
Can you explain that again, because I think that's a little,
I think I understood it. I'm good with it.
Can I just ask him to clarify that point, because there was a certain distance that he said it could only move, and in no instance would it be closer than 2195
There could be
feet.
significant changes from all the agencies that he testified to that could have issues of where the location is, whether it's the FAA or any of those other agencies. This is just a template of what you're doing. You're looking for a special exception for the use, and I understand that, but I don't think, because we don't know the exact distance, we're not gonna, you can raise your issue on standing, but I have a feeling the board's gonna wanna hear if anybody has objections. I know, I don't want it to get duplicative, we don't want it to go all night with this, but I believe, they could ask the questions and you could voir dire and have on the record your issue is standing.
Okay.
Okay.
Can I just ask him one more time to clarify the
been asked and
possible
answered.
movement of location?
I think the board understands that they're very limited. I know you said your little circumstance or the little 100-foot area, but obviously there's a lot of other agencies and bodies that are there, and there's a lot of other issues that may come up with your land development plan, soil and erosion, and everything else that you're doing. So there could be some changes that may be significant. So we're gonna allow, you can raise your issue as standing, we'll hear it, we'll make a decision on it, but as we're going on here, we're gonna allow questions from Mr. Anders.
Thank you.
Mr. Anders, for the record, could you please state the addresses of your objectors?
Want to give your address, please? So I don't-
Mr. Mangold, be sworn, please.
You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do. 96 Lipo Way, Albrightsville, 18210.
And that development?
Talmadge Trails, I live on Lipo Way.
Thank you.
Section 5.
Section 5?
Yes, ma'am.
I stand corrected, it's Dr. DiGregorio, and it's parcel number 25-51-A4.01.
It's N on the map.
N as in Nancy.
N is in Nancy.
Right here.
Okay. Mr. Pop?
Does the board want me to reserve voir dire and we can address that later for the standing? I can just maintain a reserving objection on the record.
Sure. I thought we've cleared that up already. I thought you just said that I'm allowed to ask some questions.
He's gonna be allowed to ask questions, but yeah, we could go through the standing.
Mr. Pop?
We'll do the questions, because you're not opposing him asking questions. Let him ask his questions to Mr. Pop, then, and with respect to his clients, then we'll have them put on a record where they live and where they're located. I think we already have that, but go ahead.
Right, that's fine. And actually, I can make it simple for you if you want. I don't have any objection to Dr. DiGregorio. I apologize, because my understanding is she is an adjacent property owner and received notice, so I would not have any objection to her maintaining party status. But I would maintain an objection to Mr. Mangold, because I believe he's more than a mile away from the closest turbine.
But I believe through the property line is different, and we may be dealing with a subdivision, which is gonna move the property lines,
No,
which
that's
would
not-
make it may make him an adjoining property owner.
He is not, actually, that property is not comprised of the project area at all. It's the property, Craig, can you explain where the project scope is?
I thought his direct examination is completed.
I thought
Well,
the board had a question.
I just wanna clarify this. You'll get to go, Mr. Adams.
The subject property
Right,
for the application purposes is bounded by the green line.
right.
The use, the wind turbine use, is illustrated by the magenta limit of disturbance line.
Right.
The property that Ms. Shulsky was referring to on Lippo is well away from the green tract boundary and more than a mile away from the proposed use.
Okay.
There is no subject of this application on the property that abounds Mr. Mangold's.
I understood that, but
And
you
nor would
also
the-
testified that you were that there may have been, in order to clarify some of these areas, a consolidation or a subdivision to expound the area.
No. A consolidation and subdivision plan within the green line, not without
Okay,
the green line.
okay.
So the green line is made up of, I think, 15 or more tracts. The idea was to consolidate those into two discrete lots, north and south of Hatchery Road.
Okay.
We are not looking to move any lot lines
Okay.
beyond what are
But the
shown in the-
stipulation would be that then, that it's his location of where he's located, how far away from the project area he is.
Correct, and
Okay?
that,
So you have an objection to his standing.
correct, and
Okay.
that he did receive notice under the township ordinance,
That what?
that he was not required
Okay.
to receive
We'll-
notice.
We'll keep that on the record.
Thank
Okay.
you.
Yep, go ahead. I'm sorry, Mr. Allen.
This isn't a subdivision review, is it, Mr. Poff?
We're here tonight to discuss a special exception application.
Have you filed your subdivision plans yet?
No, we have not.
So there's nothing on record as to how you're gonna subdivide this property.
There is on record my testimony indicating the intent at land development and subdivision that we are going to consolidate the lots. That's also mentioned in the narrative of the application, I believe.
Well, your intent has changed in this case, hasn't it? So your
No.
second application.
My
You
intent, may I?
Objection
may
to
I-
any reference to the prior application.
Well, you have two applications. You explained it at the beginning. He's only asking a question related to it, that it is the second application. We understand the point. We want to move on.
The issue that you're trying to address by this proposed or not yet proposed consolidation and subdivision is the principal use argument, isn't it?
One of those, yes.
What's the other?
We found that by reducing the scope of the project, we could also address some of the concerns of the community that we have heard.
Then why don't you withdraw the first application?
Because it's pending before the court, we believe it is compliant, and we intend to vigorously defend that plan until there's another alternative that's available for us to proceed with.
Okay, let's, please. It's real, enough. They could hear the testimony, please. We're taking a record, let's keep decorum here. Thank you.
When you filed the second application, you were quoted in the Morning Call newspaper. You said, "We're continually listening to community concerns and remain focused on our effort to deliver a clean energy and economic development opportunity to the region. And as a result, we submit an application for a Penn Forest wind farm that takes advantage of newer turbine technology to shrink the number of turbines." Is that an accurate quote?
Yes, that's what was printed in the Morning Call, I believe.
Well, did you say that?
Yes.
Well, I ask again then, if you've listened to the community concerns and you submitted a new application to take advantage of these newer turbines, why not withdraw the first application?
I'm here tonight to speak to the application before the zoning hearing board, and I'm glad to answer your questions to that end.
Well, you won't answer that question.
Don't go any further with that. It's understood, he answered it, he might not have answered it the way you wanted to, but it's been answered.
The DCNR, is that easement been granted?
No.
The voluntary agreement with the Pennsylvania Game Commission, it's just that, isn't it? A voluntary agreement?
Yes, in every project we've ever done in Pennsylvania, we've complied with that and will comply with it.
You can pull out of that anytime you want, can't you?
We could, we will not.
You said there are 130 homes within 1 mile of this project. You have personal knowledge of that?
We have conducted an analysis using geographic information systems to enumerate the number of homes within 1 mile of a turbine.
You conducted that analysis?
Staff under my direction.
So you don't have personal knowledge of that?
I've worked with my staff for many years and trust their work product.
You mentioned on direct examination that this use for the wind turbines is consistent with the existing use. Do you recall saying that?
Yes.
What is the existing use?
Well, it's wooded land adjacent to communities and...
Now, what's the use? We know it's wooded land. What's the use?
I don't understand your question.
You don't understand what the principal use of this property is?
No, I do not.
You don't understand the principal use of this property is the production of potable water?
No, I've heard that argument made. I don't necessarily agree with that use, nor do I know exactly what we should say is the use.
Okay. I'll revisit that in a few minutes. And just to clarify, you asked the question whether you have an agreement of sale. I was a little confused with Bethlehem Authority. You have an agreement of sale?
No, I corrected that and said we have a wind energy. Well, it's Exhibit A2. It speaks for itself.
It's the lease agreement, right? Correct?
It's Exhibit 2, license and wind energy lease agreement, yes.
And what property does that lease agreement cover?
All of the Bethlehem Authority's properties, I believe, within Carbon County and Monroe County.
Not just the property that you're pointing to below the green line.
No, all of the yellow property and a number of properties and tracts that are not illustrated on this map in Monroe County.
And those parcels are going to change then, correct? In the future, you're going to reconfigure them, subdivide them?
The properties in Monroe County?
No. I'm speaking about properties in Carbon County.
What we've talked about tonight was consolidating the tracts that lie within the green bounded line north and south of Hatchery Road.
And it's going to change.
If subdivision and land development processes are changing, then we're changing in that way. But that's all we're doing is consolidating those tracts into 2 lots north and south of Hatchery Road.
Could you explain to the zoning hearing board how that addresses the principal use argument?
I had heard the argument made. I am not saying it's a valid argument or agree with it in any such way, but it was low-hanging fruit that there is no reservoir north or south of Hatchery Road in these tracts. And so we simply precluded that further debate by consolidating those lots.
So the rest of the property has nothing to do with the reservoir, it's just the property that the reservoir is on?
I've answered the question insofar as I understand this principal use argument, which I don't purport to completely understand.
And again, I'm going to object because it's really a legal argument. It's not really necessarily a...
They'd like to make it a legal argument, but they've changed their plan to address the argument. Do you have FAA approval?
No, the FAA has not yet issued determinations.
So as the solicitor has said, FAA can tell you to move those turbines, correct?
FAA does not tell us to move the turbines.
Well, if
FAA will either determine or not determine.
If FAA determines that a turbine is in a restricted zone, then will you have to move the turbines?
No.
You'll leave it there in violation of FAA rules?
No.
What will you do, not build a turbine?
Possibly.
What's the safety plan?
I don't.
You mentioned that you have a safety plan.
Each of our projects in operation has a detailed safety plan that addresses the hazards of sites that, based on our experience as one of the largest owner-operators of wind in the U.S., is appropriate for the safe and efficient operation of a wind project. Each one of those plans includes an assessment of local EMS, site conditions, the equipment on the site, etc.
Do you have a written safety plan for this project?
We don't have a project yet. We have a proposal. So the answer is no.
Those outside agencies that you talked about that you need approvals from, do you have any approvals from those agencies?
Not all of those require approvals. Many of those are consults and coordination. So we have coordinated with FCC, as I had mentioned, and so the answer is yes. We have coordinated with some of them.
But you don't have approvals from all of them?
No, sir.
And
it would be premature.
Did you seek approvals on the first application from those outside agencies?
I'm here tonight to testify to this application.
Now, the closest home you say is 2,295 feet from a wind turbine?
Yes.
And that's actually closer than the last plan?
I'm here tonight to testify to this plan.
Why is there no written report from Mr. Bashtash that was submitted? A written report was submitted with the last application. Do you have a written report from him tonight?
We have a complete application, and Mr. Bastash will be giving testimony later tonight.
I'm asking if he submitted a written report last time. Does he?
I'm here tonight to discuss the application that's before this board.
Does he have a written report?
All right, we understand. Let's move on.
Do you have proof that these turbines are UL approved?
The specifications that are listed in the exhibit, let's see, it would be on page A5, number 6. Turbines components aren't typically UL rated. UL typically refers to the electrical components, and those are also listed on A5, number 6.
I'm not sure you answered. Do you have UL approval?
I don't believe those are noted in the design code of the turbine exhibit that I submitted with this application.
Thank you. Now, these turbines are going to be placed in an R1 district, isn't that correct?
Yes.
And you're familiar with the zoning ordinance, you testified in direct examination. Section 801B2 of the zoning ordinance is clear, isn't it? It says a lot within, and feel free to
Do you have a copy?
Of the ordinance.
Yeah, I'm not familiar with 801. We testified to 402 tonight.
There you go.
Okay. So I'm not familiar with 801.
Okay, you want to take a look at it?
I don't know that I'm going to, I see it on the page.
Okay, well, you testified earlier, you're familiar with a lot of the parts of this ordinance.
402, 854, I know backwards and forward.
Well, I'll read 801B2. Does it state that a lot within a residential district shall not include more than one principal use?
Objection, I think this has been asked and answered a number of times.
That question hasn't been asked.
Please, please, please.
Is that correct?
I didn't hear a question.
Does that section read that a lot within a residential district shall not include more than one principal use?
And shall not include more than one principal building unless specifically permitted by this ordinance.
What do you understand that to mean, one principal use?
I think the ordinance speaks for itself.
Isn't it true that this application is simply an amended plan?
This application speaks for itself.
Well, I'm asking you, do you believe it's an amended plan?
No. This is an application with a separate fee, a different date, different parcels, different proposal.
Let's take a look at the should For one moment, please. I think the cover letter says that note that this application is new proposal and the new plan is different from the prior application. Do you agree with that?
Yes.
Take a look at the narrative in support of that first application, if you would.
The first application?
Yeah, and we're going to compare it with the second application.
I mean, we understand. I think we brought this up right at the beginning. I think we need you guys to brief this as a part of findings of fact and conclusions of law. We understand that we see that there are two separate applications, one that was deemed approved and another one that's different in some aspects, but for the same type of requested use, being the wind turbine facility.
Well,
so I'm missing why we're going into the similarities between the two plans, and trying to split hairs of whether it's an amended plan or a new plan. Isn't that more of a legal argument that the board would like to have presented to it?
If the board would like it,
because I think they understand. They sat through the whole testimony, although I wasn't here in that first proceeding, and they see what's being presented now. So I think they understand the differences, and we're playing on a nuance of whether it's an amended plan or a new plan. And I don't think he's going to admit to that, nor not give you the answer that you want with that. But we will look at
that's fine.
What's been presented. I think we understand the argument.
Have you reviewed the conservation easement that you entered into?
What conservation easement are you referring to?
Well, the conservation easement between Nature Conservancy and Bethlehem Authority.
I did not enter into that agreement.
I know. Have you reviewed it, is my question.
I'm aware of it. I would not purport to be an expert on that document. I'm aware that it exists, but I have no specific knowledge of it.
Well, you say you're not sure about principal use. And if I may, I'd like to ask some questions about the principal use. I think it's important. I understand you believe it's a legal issue, but I think we need to put something on the record with regard to that so we can make arguments.
So which agreement are you referring to? Was that
this is a term conservation easement.
No, it's not in the record.
I'm not sure it was submitted the last time as an exhibit. We'll submit it as objectors exhibit number 1.
Can I have a copy, please?
No, it's not. Okay. So you want to show them that exhibit?
Yeah, take a look at that exhibit.
We'll have them review it, and then you could ask them questions concerning it?
Please.
Yeah, we're going to
And I'm not exactly sure where the questioning is going, so maybe I should hold off. But to the extent, the board is probably well aware, private easements have nothing to do, it's not a proper zoning consideration. So to the extent that there's some issue with respect to the easement itself, it's not a proper consideration before this board.
Well, we haven't seen it. I haven't seen it.
either.
I haven't heard any testimony on it, so before we could even get that far, I think we're going to have to develop it a little bit.
Appreciate that. Take a look at that, if you would, please.
Okay, it's a conservation easement.
And you said you're aware of it, but you didn't review it?
I said I'm not aware of the specifics of it.
Okay. Is your engineer aware of the specifics of it?
Can I interrupt for 1 second? Who is this easement between?
Bethlehem Authority and the Nature Conservancy, it appears.
So the owner of the property that you're subject to a license agreement with also has an agreement with a conservation district?
You know, a conservation organization called the Nature Conservancy.
The point is this, that the property is encumbered by this conservation easement.
Okay. All right. And this is filed as a record, and you're submitting it as an exhibit. All right.
Take a look. That's dated, and I'll try to move through it quickly. That's dated April 14 of 2011, correct?
Yes.
It's between the Bethlehem Authority and Nature Conservancy.
Yes.
And on page 1, it talks about the protected property. Do you see that in the first whereas clause?
I see protected property.
I would object. The applicant's not a party to this agreement. They're asking him to interpret an agreement that he's not a party to.
I'm not asking him to interpret it. Just I want to go through it with him. His lease agreement refers to this conservation easement. The lease agreement between...
Is it subject to?
Absolutely.
Is the agreement subject to the lease, to that agreement?
It refers to this. But this conservation easement does not preclude us from our proposal.
All right. If your agreement with the authority references that is subject to or references that agreement, he can question on that agreement.
It states that the protected property, which has ecological, scientific, educational, aesthetic value in its present state as natural area, which has not been subject to development or exploitation, but is currently utilized for the production of potable water. Did I read that correctly?
I believe you did.
So
There's more, of course.
I'm reading the relevant sections. I'm not going to go through the entire easement agreement. You can point out on redirect anything you wish to point out. But doesn't that tell you right there that this protected property, and by the way, your lease is for the entire property, is it not?
It's for whatever the lease enumerates in the lease.
Is for all of Bethlehem Authority's property in Carbon County. Isn't that correct?
I'd have to refer to the lease.
Okay, well, if you take my word for it, and we can get to that in a few minutes. But you agree with me that this conservation easement references this property, protected property, and it's currently utilized for the production of potable water.
I do not concede that it even, what property it refers to, because
the entire, doesn't it refer to the entire Bethlehem Authority property?
I'm looking at an exhibit on the back of this that says Tunkhannock. This does not refer to my property.
Well, I think you're incorrect with regard to that.
That's in the exhibit.
Sure. We're in Penn Forest Township. That's IU. That's not this one.
I may have a copy that doesn't have it.
Okay?
Attorney Anders, was this one of the handouts from
Prior application.
prior meetings?
Yes. My point in all this is that the protected property.
No, we're not going to refer to that agreement that does not apply to this
All right,
property.
well, let's look at your lease agreement then, okay, for the time being.
Yeah.
The windows open. They have those windows open. You mind if I look at this? You guys mind?
No.
Let's take a look at the wind license and wind energy lease agreement. I'll enter this as objectors number 2.
So, is 01, wait, has anything been authenticated? It's 01. Have we decided what that document is?
Well, that is the conservation easement, and I will tell you what, we don't have, there's one page missing that shows, it covers the property in Carbon County. But there's a page missing on the lease agreement, the exhibit.
Okay.
I can see that.
Well, obviously it's filed in Carbon County. What we'll do is, we'll take zoning hearing board will take judicial notice to the extent that it's contained, what is recorded in Carbon County deed book number 1911, page 103. I didn't count the number of pages that say that there's 28, but it looks a little, goes from 104. So to the extent that if the exhibit is not attached, it shows it's Carbon County, we'll take it subject to your objection, and it won't be considered, but it will be marked, and it'll be admitted as was recorded in the Recorder of Deeds office.
Okay,
So
I
we'll
have
the
a full
question
copy
on
of it right now that does, in fact, that's my fault.
That's
We
all right,
made
that's
copies,
understandable.
we
I know.
forgot Exhibit C. I think Mr. Pop is well aware of that.
Okay. All right. So in fact, in addition to those exhibit 1, 2, oh, there's a lot of exhibits. Is this the full, complete, and it has tax parcel numbers? These tax parcel numbers are part of the, Mr. Anderson?
Yes.
These tax parcel numbers
They are.
part of this recording?
They are.
That's gonna be objectors 1, I believe. That's fine.
Against our application.
Have you seen that document before?
I don't know it's this complete, true, and correct copy,
Okay.
but I'm aware of the Nature Conservancy
To the-
agreement.
Once again, what we'll do is I will, on behalf of the board, pull the exact parcel, and that's what will be admitted, okay? The exact deed book and page reference, and we'll make we'll take that as judicial notice, and we'll put that as part of the record, subject to any relevancy objections that are made.
Thank you. Mr. Pop, take a look at page 3. The next to last sentence in paragraph 1. It begins, the grantor intends. And I'll read it for you. You tell me if I read it correctly. The grantor intends that this conservation easement will confine the use of the protected property to such activities as are consistent with the purpose of this conservation easement, and shall specifically include grantor's right and ability to manage and operate the protected property in order to produce potable drinking water for the customers of the city's water system. Did I read that correctly?
Yes.
And the grantor it refers to is the Bethlehem Authority, does it not?
I don't see where, I presume so, but again, I'm not.
Well, take a look at the
you're
first.
asking me
Take a
to
look
do
at the
this
first page, Mr.
on the
Pop.
fly.
Who was the grantor listed on the first page?
Yes.
Yes?
Yes.
And you agree with me that the intent of this conservation easement, according to the conservation easement, is to confine the use of the protected property to, which includes the right of the Bethlehem Authority to manage and operate that property in order to produce potable drinking water. Do you agree with that?
It says it shall specifically include grantor's right and ability to manage and operate the property in order to produce potable drinking water.
That's
Yes.
the use. Do you agree with me? That's the use
No.
that is being made of that property?
I do not.
You do not?
I agree that what you read is what this says. I see that it shall specifically include grantor's right and ability to manage and operate the property. And I believe it's within the authority's discretion on how they do manage and operate the property, as they do today and have for years through forest management, through prescribed burning, through carbon credits, and now with the proposed wind energy project.
Do you agree with me that the use that the Bethlehem Authority makes of this property is for the production of potable water?
Again, as I indicated
We're splitting hairs with it. We see what's in the conservation easement. We understand the testimony. Let's move on.
Take a look at page 5 of the same agreement. Paragraph 2.6. Does it not state that other than required by the grantor's obligation to supply drinking water to the city and its customers, in accordance with paragraph 3.1 of this agreement, There shall be no pollution, alteration, depletion, or extraction of surface water, natural water, etc. Did I read that correctly?
There's no et cetera in there.
Well, I didn't read the entire.
You're right.
But I read the first part correctly?
Yes.
All right, come on. Let's not.
Okay, let's take a look. Let's take a look at the lease agreement. You are familiar with that document, are you not?
Yes.
And do you have a copy in front of you?
No.
Does your counsel have a copy?
No.
Have I offered this as exhibit number 2, objectors number 2?
And that would be, what was that?
This is a lease agreement between, it's a wind license and wind energy lease agreement between Bethlehem Authority and Atlantic Wind LLC.
That's good.
And what's this marked as, 02?
02. Mr. Poff, you agree with me, this is dated March 6th of 2013?
The copy I have is illegible as to the date, but this appears to be the document.
You are familiar with this document?
Yes, of course.
And it's between, as I said, Bethlehem Authority and Atlantic Wind LLC, correct?
Yes.
Atlantic Wind LLC is an Oregon limited liability company?
At the time of this agreement, and I believe still, yes.
And could you
Hey,
read,
come on.
could you read the first sentence of paragraph 3?
Throughout the term of the agreement, Atlantic shall have the sole and exclusive right in Atlantic's sole discretion, provided that it is in accordance with the term conservation easement, as such term is defined in section 10.3, and the primary mission of the landowner to produce potable water to use the property for wind energy purposes and to convert all wind resources of the property.
So it states that the primary mission of the landowner, Bethlehem Authority, is to produce potable water, correct?
It says what it says.
Do you agree that it says that?
Enough. We understand what's written in the agreement. You want to submit that agreement, is filed as of record, that's in, I think the board understands that.
Well, Mr. Pop, isn't it true that the lease agreement is for a second use on that same property?
Again, I don't understand the question that you're asking.
Well, Atlantic Wind, how is Atlantic Wind, what's the use Atlantic Wind's going to make of this property?
We are proposing the wind energy use as permitted under our lease and license agreement with the authority and the zoning regulations in effect.
And that's a separate and distinct use from the use of the Bethlehem Authority to produce potable water, is it not?
I do not agree with that assertion.
Well, let me ask you this. Once you put up your wind turbines, if this is approved, will the Bethlehem Authority continue to use that property to produce potable water?
It's up to Bethlehem Authority to determine how.
All right, enough.
To use the property.
Has Bethlehem Authority indicated to you as the lessee that they are going to terminate the use of the property to produce potable water?
Bethlehem Authority has made no representations to me as to their use of the property.
Take a look at paragraph 9.1 of that agreement. Would you read the first sentence, please?
Landowner expressly reserves the right to use the property for any and or all other lawful purposes, including the uses set forth in the term conservation easement and the landowner's use of the property for the production of potable water and any related uses thereto.
The primary uses.
Yeah, as defined in this agreement, but only to the extent that any such use by landowner does not, except for the primary uses currently or in the future, interfere with Atlantic's operations hereunder or enjoyment of the rights hereby granted to Atlantic, and any such use does not include wind energy development or installation or use of any facilities related to the wind energy development or generation.
That's fine, thank you.
Yeah.
So this, again, this references the primary use of this property is for the production of potable water. Do you agree?
No, I agree that the language says what the language says.
That's the state. I think the agreement speaks for itself. You're not gonna. Obviously, he doesn't feel that that's the primary use of the property, but the agreements say what they say. We understand it though. We understand the argument.
Thank you.
And you guys, please, you guys gotta keep it down.
Mr.
Side
Pop,
comments aren't helping out at all, and it makes it difficult for any of us to hear, especially the court reporter. Please, please.
Mr. Pop, where is the operation and maintenance building going to be located?
Off-site. It's not a,
Where it's going to be?
no, sir.
Fine. Will you tell us what zone it's going to be in?
No, sir.
Do you agree with me that that's essential to the operation of your wind turbines?
It's important, essential. Yes, there will be an operation and maintenance building nearby.
You just won't say where.
That's exactly right.
There are temporary Met towers on the property, correct?
Yes.
And what type of approval did you seek from the township to get permission for those Met towers?
We obtained 4 conditional use permits.
And you agree those Met towers are obviously related to this project, correct?
No, they're not a subject of this special exception.
No, are they related to the project?
They are not a subject of tonight's application.
Are they related to the project?
They are not a subject of tonight's
I'd ask that
application.
he be directed to answer the question. I'm
No.
not sure if they're related to the project.
No,
Would they be there but for the project? I mean, would you just put up Met towers and nothing else?
we have put up Met towers and not proceeded with special exception.
And is that what you intend to do in this case, just to put up the Met towers?
We have an application here tonight.
Does your current application address the temporary Met towers?
There's nothing in the current application addressing the Met towers, no.
How many permanent Met towers are you proposing?
There's one proposed Met tower on the special exception application before the board
Do you
tonight.
agree with me that that's very similar to the temporary Met tower?
No, I would not.
How is it different?
It has a permanent power supply and a foundation, and it's built, it's a permanent facility rather than a temporary facility.
Both are freestanding, you agree with that?
Define freestanding.
They're not, they're standing of themselves. There's nothing securing them to the ground other than what's in the tower itself, part of the tower.
Well, the temporary meteorological towers have some guy wires to them. A permanent one typically does not.
So would it make sense that you would be required to get a conditional use application for the Met Tower that's related to this project?
No.
Why not?
As we indicated in our application, it's an appurtenant use to the construction of wind turbines. You must have a permanent meteorological tower for the instrumentation independent of wind turbines.
Why did you get a conditional use for the...
May I please finish?
Sure.
And it is, you can't have one without the other. And to the extent that the zoning hearing board feels differently, we have requested, as part of our application, a second special exception for that specific use, because permanent Met tower is not otherwise noted in the zoning code, nor is it expressly prohibited.
But you did not seek a conditional use approval for that Met Tower, am I correct?
For the permanent Met tower?
Correct.
No, we're seeking a special exception as it's part of this application.
Just a moment, please. You talked about this project is no different than, or strike that. You stated that your project conforms to the zoning ordinance, correct?
Yes.
That you think you're in compliance.
Yes, we've enumerated
Wouldn't
all those standards.
Wouldn't any other wind project also have to comply with the zoning ordinance?
I would presume in order to obtain a permit, it would have to comply with the ordinance, yes.
So yours is no different than any other proposed wind turbine project with regard to the necessity to comply with the ordinance?
With regard to the necessity, no.
Thank you. Are the permanent towers attached to a structure?
They are a structure.
So they are a structure, a freestanding structure.
Sure.
Are they taller than 20 feet?
Yeah, as we indicated to Mr. Fogel's question, I believe it's 370 feet.
And they're not accessory?
I don't believe they are an accessory. No, they're an appurtenant use, just like the cabling and the substation and the road access. But to the extent the zoning hearing board feels otherwise, and it's not prohibited, that's why we included that.
It's a double argument with it. I think the board understands that it's either a separate special exception, or it's because it's not defined, meteorological towers. I said it right for the first time today.
You got better than me.
If it's not in there, then it would be a special exception in and of itself, or else it's a use either pertinent to or accessory to what they're planning on doing. It's one or the other.
You understand the argument?
And yeah, we do, absolutely.
Thank you.
Now, was there anyone else that had questions for the witness?
I do.
Okay. You're gonna have to come up and state your name for the record.
John William Fontaine,
Spell your last name, please.
Fontaine.
I'll swear you in. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr.
Excuse me.
I'm gonna find out. Mr. Fontaine, are you an attorney representing somebody?
No, I would be in this matter as pro se, representing myself.
Okay, and are you a property owner?
I reside in 82 Bluebell Lane, Penn Forest Township.
Okay. Where's that at?
Sunrise Ridge Development.
Okay, where's that? Is that the bottom?
No, it's
not on the
it's
map.
not on the
Not
map.
even on the map?
No.
It's on
All
the-
right.
It's on the other side of Japan.
Okay. There, you can volunteer as to standing, but if he just has a question or two,
Yeah,
I don't think it would hurt.
No, I don't have a problem, and I certainly don't have a problem with you asking questions. I was just gonna suggest, depending on, and I don't wanna cut you off if you have more, but if it's just a few, if it's more than a few, I was gonna ask if we could bring Craig back, and he's happy to answer as many as you have. But we have a witness that flew in from Portland, Oregon, that I was hoping to put on next and
Okay.
get through this evening. So,
That-
but I'm
if you-
certainly welcome
I mean,
to recall him for you, or if
That
you
would
just
be
have a
fine.
few.
Okay.
You wanna do that?
Let's do that recall, because you do have somebody
Is that
here.
okay?
That's fine.
Okay.
We're gonna make sure that we're able to get this witness in.
All right,
because we
appreciate
have
that.
it from Portland. Okay.
He's much more expensive
No,
than me.
we're gonna recall him. You're gonna get your opportunity for him, okay? Not now. There's somebody here from Portland, we wanna get, put the record with him. You guys that was this one. I didn't realize.
And thank you, I really appreciate the board's indulgence on this.
Thank you.
I don't even bring copies for me.
Not the applicant.
Oh, yeah, I have everything.
Like I normally do.
All right, Mr. Bastache, could you state your full name and address for the record, please?
Mark Bastash,
2020 Southwest 4th Avenue, Portland, Oregon.
And with whom are you employed in what capacity?
CH2M, I'm an acoustical engineer.
And can you describe for the board your educational background, please?
I have a Bachelor's of Science from Cal Poly San Luis Obispo and a Master's of Science from Rice University, both in environmental engineering.
And in what disciplines did you receive your bachelor's degree?
Environmental engineering.
Okay, sorry about that. It's hard to hear you.
Yeah, no problem. Did I shut the window?
Sure. Yes.
Or close it down a little bit?
Can you hear okay, Andrew?
Mm-hmm.
And in order to become an acoustical engineer, did you have to receive any specialized credentials?
I did. I sat for a PE exam with the state of Oregon, just like a civil engineering exam. State of Oregon has a PE exam, which I sat for and passed.
And can you describe for the board what is an acoustical engineer?
So acoustical engineer is one who looks at the acoustical output of projects and designs sound control measures or evaluates sound control, whether it's from outdoor sources such as emergency generators, power plants, or indoor facilities and dealing with HVAC and other sorts of sources.
And how long have you been an acoustical engineer?
Approximately 20 years.
Do you currently hold any professional registrations or memberships in professional societies?
I do. Beyond being just a professional engineer, I am a member of the Institute of Noise Control Engineering and the Acoustical Society of America.
And in the area of wind turbine sound, have you authored any professional publications or have you participated in any presentations in that field?
I have. I've authored several presentations, and papers, including articles in Canadian acoustics, multiple presentations to various conferences, domestically and internationally. I sit on the organizing committee of the International Institute of Noise Control Engineering Wind Turbine Conference. I was invited to be a plenary speaker at a joint conference between the Australian and New Zealand acoustical societies and prepared a paper presentation for that event.
And were any of these publications peer reviewed?
Some were, yes.
And how many acoustical analysis do you think you've performed in the course of your career?
Probably over 1,000 general acoustical analyses of one sort or another.
And do all these involve wind energy?
No. Work on a variety of projects, whether it's a gas-fired power plant, a coal-fired power plant, municipal wastewater treatment plant, highways, data centers. It runs the range of acoustical sources.
And how many acoustical analyses have you prepared specifically with respect to wind energy facilities?
On the order of 100.
And I'm showing you what's I have marked as Exhibit A7. I believe you have a package. Is that a copy of your curriculum vitae?
It is.
And your curriculum vitae also goes into more detail about your education background and experience. Is that correct?
It does.
And have you previously testified in proceedings before state and local agencies, panels, and boards, and have you been accepted in those proceedings as an expert in the area of acoustical engineering?
I have.
And can you give a few examples of some of the various boards you've appeared before and offered expert testimony?
Before we keep beating us to death, is there anybody that has any objection that he's an expert in acoustical engineering? Okay, he's an expert in acoustical engineering.
Have you ever not been accepted as an expert?
We've already accepted him as an expert.
Thank you. Quit with your head, right?
Yep.
Okay. Mr. Pistache, were you retained to review and analyze the project that Atlantic Wind has that's currently before this board this evening?
I have. I
And
was.
And are you familiar with what's being proposed, the surrounding area and the land use?
I am.
And have you had an opportunity to personally visit the site?
I have.
Hopefully not in today's weather, but another occasion, right?
Correct.
Similarly, are you familiar with the Penn Forest Township ordinance insofar as it applies to sound levels with respect to wind turbines?
I do. I am.
And is it your understanding that ordinance section 402A 54P requires that the sound for wind turbine not exceed 45 dBA as measured at the exterior of an occupied dwelling unless a waiver is provided by the owner?
That's correct.
And can you explain briefly for the board what's a dBA?
So a dBA is a measure of volume, decibels is a volumetric scale, or a volume scale in terms of sound level, just like the volume on a TV or your car stereo. The higher the decibel level, the higher the volume. The A weighting is a representation of how the human ear generally responds to typical environmental sounds. It's the most common metric used in regulatory ordinances.
And did you prepare a report summarizing your sound analysis of the proposed Atlantic Wind project in relationship to the township ordinance?
I did.
And directing your attention to Exhibit A8, is that a copy of your report that you have before you?
It is.
So we're going to kind of work a little backwards here based on your analysis using the best available technology, industry standards, and methods, and your extensive, obviously, experience as well in the field of predictive modeling. What is your conclusion in that report?
Our conclusion is that the predicted sound levels comply with the ordinance.
Let's walk through your report briefly, and you can discuss how you reached that conclusion. For the benefit of the board and those present, can you briefly describe the predictive method you employed in reaching your conclusion that the project sound levels would not exceed 45 dBA at any occupied dwelling?
Certainly. We utilized the vendor's sound pressure level information that is specified in an international standard called IEC 61400-11 that identifies the sound emissions coming from the turbine. We used the highest or the highest sound level noted in the vendor's documentation. We assumed that all turbines were operating at that sound level. That was included into a propagation model that is based on ISO 9613-2, which is the method for propagating sound outdoors. We used a ground absorption coefficient of 0, which means we're not accounting for any potential ground absorption, and we used a receptor height of 4 meters.
And the commercial software that you mentioned that you employed, is that authoritative and a reliable software?
It is. The software we used is what that implements the ISO 9613 method is called CADNA-A. It's been used by researchers and regulatory bodies and others in this profession as well.
What is it called?
CADNA-A, CADNA/A.
And what turbine model did you base your analysis on?
The Vestas 136.
And when you say in your report, the method is based on an omnidirectional downwind condition, can you explain for the board what that means?
Sure. So the model predicts sound levels, presuming that the receptor is downwind from all the sources simultaneously. So what that means is that if I'm sitting in the center of a source that's linear. Oh, thank you. So if we have a string of turbines, I'm trying to point myself to you guys. We have a string of turbines here, and I'm predicting the sound level at this point. The model is presuming the wind is coming this direction from that turbine, this direction from that turbine, and this direction from that turbine. Obviously, wind does not flow in that kind of direction, but that is the basis of the modeling method that is used.
So in reality, is it likely that all those conditions would ever exist feasibly?
No, it's kind of an impossible wind condition to exist. You don't see black hole type wind conditions, but this modeling method has been used reliably for these types of projects.
And has this model method ever been evaluated on behalf of a state agency?
It has. The state of there was reports done on behalf of the state of Massachusetts that utilized the very same modeling method.
And does your report include a table offering a summary of the predicted sound levels?
It does. That's table 1.
And can you describe for the board and for the benefit of the audience what's depicted on table 1?
So this tells you for each sound pressure level, how many occupied dwellings are predicted to be at that sound level. At the sound pressure level of 45, there are 0. At the sound pressure level of 44, there are 0. At the sound pressure level of 43, there is 1.
And as part of your report, did you identify the contour line for the threshold for the 45 dBA limit?
Correct. That's included in figure 1 is a depiction of the 45 dBA prediction.
And I believe that was one of the questions that the board member had about where specifically that threshold, where that line was. So is it the blue line?
That's correct.
Will the applicant be required to obtain any waivers from any property owners in order to comply with section 402A 54P?
No.
And you also noted in your report that the results are subject to both negative and positive variances. Can you explain what that means?
Certainly. So if the project is, we're presuming all the terms are operating at a sound power level of 107. And that would require sustained high winds throughout the entire project area. If we don't see sustained high winds throughout the project area, some turbines will be operating at a lower sound pressure level, so we might see some lower sound levels under those conditions. If the project is operated during a condition where there is an abnormal condition where there might be ice accumulating on a blade, such as a freezing rain event or whatnot, then there's the potential for the sound level to be greater than the 107, but the applicant has the ability to control and limit the operations under such events, and such events require the simultaneous nature of both cold weather, humidity, the adherence of ice on a blade, and elevated winds, so the turbines are actually operating. And then again, the owner-operator maintains the ability to control the entire facility to limit operations.
So it's a confluence of several conditions. It's not just icing on its own that could potentially cause that. It sounds like what you said is a number of conditions.
And they'd have to be operating under those conditions, correct?
Now, you mentioned an owner-operator could comply. How about this particular applicant? Will the applicant here agree to comply with the sound levels under any situation, even these anomalous situations that you just mentioned?
That's correct. That's my understanding.
Now, as a sound expert, in your opinion, is it appropriate to analogize the 45 dBA ordinance standard to a maximum speed limit?
No, the LMAX approach is problematic for a number of reasons. Not the least of which is it's not predictable. The vendors don't provide any data that would allow one to evaluate an LMAX criteria. It's not repeatable from one event to another event. It's therefore has high variance and is not considered reliable in that regard.
Now, you're not here today to testify as a public health professional, are you?
I am not.
And you're not here to offer any expert testimony in the area of health effects on wind energy, correct?
Well, I think he's been only in the acoustic engineering. That's the only thing that he's been as an expert in.
To the extent you mentioned a particular turbine specification, to the extent that any of the specifications are materially different when the project is built, because you heard Mr. Pop testify that technology is always changing, and with all those various third-party permitting, it could be even more improvements by the time it's built. Is it your understanding that the applicant would provide an updated analysis to confirm again that the predicted levels will continue to comply with what you predicted in accordance with the maximum 45 dBA standard?
Certainly, should the turbine technology change or be updated, or if there are minor shifts in the layout, an updated analysis can readily be prepared.
And finally, were all the opinions that you offered today based on the best available technology, industry standard, means and methods, reasonable engineering methods, and of course your extensive experience in acoustical engineering over the last 20 plus years?
Yes, so the modeling methods used in this analysis are consistent with those used and referenced by other regulatory bodies.
That's all the questions I have of this witness.
Anybody on the board have any questions?
I just didn't understand one thing that you said, and you might be able to correct me. You said the manufacturer gives you the information, but some of the manufacturer's information is not the correct information on the sound level from them. It's hard to get the true, accurate sound level coming off of the unit.
No, I don't think
It's something on that line that you said about going back to the manufacturer of the product itself is
No, I think what we were just talking about is should the turbine technology change, and an analysis can be done with the turbine that would be as built or with the latest and greatest sound information. The IEC 61400-11 data is typically readily available from the turbine vendors, so that's usually not a challenge.
Thank you.
Any objectors have any questions for this one?
I do, but we've just been handed this report. We haven't had an opportunity to review it at all. I would ask that.
Well, it's you know what? It is a zoning hearing, so you generally don't get these ahead of time.
Well,
when an applicant comes in, I mean, you've done enough zoning, so have I. An applicant comes in, they have their stuff. You don't get it ahead of time.
We may have 10 minutes.
We'll recess. We'll take a 10-minute break. We've been going quite a while. You need a break, don't you? Absolutely. We're off the rail.
Turn your camera.
You waiting?
I know it's
The only two that you didn't forget.
Does that affect the sound propagation?
Here's our sound expert now. Rick, can you hear us? I can't hear you. Yeah.
All right, Rick, why don't you shoot some questions for me?
Text.
He didn't say, though, the average. The report doesn't say average.
But that is the average. And he's saying those 2 cars to get the maximum because that's not his problem. That's his problem to take care of. We know the sums of wind turbines exceed the predicted level by 5 years.
I'm sorry, you said does the...
Right, yeah.